Thank you for joining us today on Risky Business, brought to you by Marble Law Firm and HR Synergy. My name is Michelle Gray, and I am the president of HR Synergy, located in Bedford, New Hampshire. We provide outsourced human resource consulting services for our clients in the area of labor law compliance and employee communication tools. Also with us today is Katie Marble of Marble Law Firm.
Hello, I'm so happy to be here today. As Michelle mentioned, my name is Katie Marble of Marble Law Firm, also located in Bedford, New Hampshire. And we provide employment law services to business owners in New Hampshire and Massachusetts, and that might include state and federal wage and hour issues with state and federal agencies, as well as defense of lawsuits and claims brought by employees, and just generally trying to help business owners avoid getting sued.
That's a great thing.
Yes, absolutely. They like that.
So with that in mind, Katie, actually, there is a new leave that is up and coming in Massachusetts that employers want to be aware of or need to be aware of because it's going to be effective this coming April, on the 7th of April. And there's some very important guidelines that people need to understand. Would you like to share that with us?
Absolutely. So as you mentioned, on April 7th of this year, Massachusetts is expanding what was the maternity leave law to now be for parents. So it's now the parental leave law. And so male and female employees may be entitled to take time off for the birth or placement for adoption of a child. And this law will govern businesses that have 6 or more employees and will require them to provide 8 weeks of parental leave to male and female employees for either the birth of a child, the adoption of a child under the age of 18, or the adoption of a person under the age of 23 who has special needs. This will be allowed for full-time employees who have been employed for 3 consecutive months or longer. And if parents work together at the same company, they're only going to be entitled to a combined 8 weeks of leave. So they can't double up and say, we want our 16 weeks of leave. And when parents return from this parental leave, they are entitled to be reinstated to the same position or a similar position, barring certain exceptions, which might be, a reduction in force that would have affected the position anyway, or a restructuring that would have affected the position anyway, whether or not that person took the leave. So employers need to understand this expansion for parental rights and parental leave, make sure their policies conform with this statute, and just make sure that they're doing everything that they're required to under this law to provide this additional leave to their workers who are parents.
So maybe we can backtrack a little bit. So how long does someone have to be employed to be eligible?
3 months.
3 months.
That's it.
That's not much.
Not a lot.
And it's fully on part-time?
This one's just full-time.
Okay.
And I looked at the statute. It doesn't necessarily set out an hours number, but it looks really at kind of the totality of the employment and as to whether it's full-time.
Mm-hmm.
And
so really the employer would define what full-time is?
I think as long as it's reasonable. I think if you're, as an employer, you said, all right, full-time is only 40 hours, nothing less, I think that may cause some problems with the state agencies who are going to be enforcing this leave.
Right.
But, if it's a legitimate full-time position, I would say probably, you're talking 30-ish hours or higher. Mm-hmm. But I would certainly take a look at the position as a whole in context, too, with your entire workforce. And really make sure that you're defining your full-time employees in a pretty fair and reasonable manner.
Husband and wife, domestic partners, what have you, work for the same company. Mm-hmm. How's that going to work?
8 weeks only. They can't stack the time on top of each other, so that they're going to have to work out who's taking off, how much time, and when. And employees are allowed to take this time at the time of the birth or adoption, not significantly earlier or significantly later. So generally, if you have a husband and wife duo, that say, we're each going to take 4 weeks, and mom will take the first 4 and dad will take the second 4. That's going to be fine. I think if you're saying, well, I want to take 6 weeks now, and then I want my partner to take leave in 10 months from now, that's not going to fly. It really is, the focus is on the early bonding period of either a new child who's born, or an adopted child who's coming into a new situation in your home, and trying to provide leave for that initial period of time when kind of that family changes are happening.
Right. So this can be a little complex, and just kind of justifies why you definitely need to have this documented in your handbook or a policy developed to, because there's so many different leaves, and this has some very specific guidelines. It's a great expansion for the family, I think, to give both parents the opportunity to bond with their child, whether it's an adoption or natural birth, whatever the situation is. I think that's important. So this is definitely some great news. Now, when we talk about, is there any type of tracking that they have to do specifically, or?
Well, any kind of implementation of a new statute like this is going to really dictate a lot of your HR practices. So one thing that the statute does say is that if you take your 8 weeks and then you extend it, the company can't use that against you except for very specific circumstances. So I'll do an example rather than kind of talk you through it, because I think it's a little bit easier. So like this is in my example, Michelle works for me. So that works very well for me, because Michelle's an excellent worker. So
I'm the greatest boss.
Yes. So if I say to Michelle, all right, you can have your 8 weeks, just sort of circle back to me as you're getting closer, and we'll talk about bringing you back on when you're done. That's great. I'm complying with the law. I'm allowing you your time off. But if you don't get back to me, and I kind of lose track of time, and it's 10, 12 weeks, and I think, oh, wow, I haven't heard from Michelle. She's fired because she never got back in touch with me. I can't do that unless 2 things happen. One is, before you go out on your leave, I give you notice in writing that if you take longer than your 8 weeks of allowed leave, that you could lose your right to reinstatement, and you may lose certain benefits. And then at 8 weeks, when I say, okay, Michelle, you're due back next week, if you don't come back, this is what's going to happen to you. And I again give you that written notice, letting you know that you may lose your chance for reinstatement and you may lose benefits if you don't come back. Then I may be entitled, and I always say may, because there are all sorts of crazy things that come up in these real life scenarios. But then I may be able to terminate your employment if you just say, I'm not responding to you, I'm not coming back, I don't care. But if I don't give you those notices, because really what it's doing is protecting you, making sure that you understand what your responsibilities are. You have certain rights to take time off, but you also have responsibilities to communicate with your employer about your return. If you don't know about that, the state is saying it's unfair for the business owner to hold that against you. So it really, yes, you need to have your policies in place, but you really need to have good practices for tracking,
right?
And making sure when people are supposed to come back, and make sure that they've gotten all of the documentation along the way that they should be getting.
So, and that's a key word that you mentioned, is documentation. Documentation is not verbal.
Right.
It's written.
Right.
It's making sure that the employee is signed off on it as well.
Yeah.
Because even though you review information with them, doesn't necessarily mean that they will say later down the road, oh, they never showed me that. Oh,
right.
So your proof is always having the employer sign off on it, and whoever did the review of the practice with that person.
Right.
To sign off on it as well.
Absolutely. It's key.
Now, has the law provided any forms, or is this something that employers are going to have to start thinking about, not only updating their, employee handbooks and policies, but developing the forms that can be used consistently across?
At this point, I don't know the answer to that, where the law hasn't come into effect yet. It may be that there will be some samples that are provided. I would say Massachusetts typically does a very good job of providing samples that can be then tailored to the employer's workplace. So at this point, I don't know. They will be issuing, obviously, a posting too. that will be the required standard posting that Massachusetts needs to put up in a conspicuous place with all of their other labor law posters. So I would certainly keep an eye on that because, yeah, if there's something that they provide that, can help employers not reinvent the wheel, that's always very nice.
Right.
But at the end of the day, whether or not there are samples going around the internet or not, it's really up to the employer to make sure that they are providing the information required by law. And so they need to really make sure that whatever it is they're handing out conforms with what the statute says.
Right. And don't wait for the Department of Labor to develop the forms. If they're not there, you got to do your own to keep yourself on the ball. Train your managers and supervisors how to deal and how to address this type of situation when an employee who may not be having the baby would like to take some time off to bond with their child.
Absolutely. And that's another thing. Under the statute, it's only 2 weeks' notice. Obviously, when you have a female worker, at some point you start to become aware that they're going to be having a baby. But if you have a father in your workforce, you may not know what's going on at home, and you may need to be prepared that you'll be offering leave with a fairly short lead time.
Right, but for a small employer, that could be a real hurdle. So I think the communication and relationship that you have with your employees is really critical to be in the know
Absolutely.
as soon as possible.
It goes back to corporate culture. You want to have the type of business where your employees feel comfortable coming in and talking to you. You don't really want them holding off to the 2 weeks just because they feel like if they tell you about it, there's going to be some repercussions for them. Obviously, legally there can't be, but not all employers do that and are following the letter of the law. So it's very important for that open communication to have that be part of your corporate culture. I know it's not a legal thing, but it really helps with those legal issues.
Absolutely. Absolutely. I agree with that. So I think this is some great information here. And if you have some additional questions, feel free to reach out to Katie or myself. I'd like to thank you for joining us on Risky Business. And again, my name is Michelle Gray with HR Synergy. I can be found, my website, at www.hrsynergyllc.com. Please like us on Facebook, follow us on Twitter, connect with us on LinkedIn, Google+, etc.
And I'm Katie Kiernan, Marble Law Firm. My website is nhemploymentlaw.com. You can also find me on Facebook, Twitter, Google+, LinkedIn. If you have any questions, you can reach me at my email is katie@nhemploymentlaw.com. And Michelle, why don't you give them your email address too, just in case somebody has a question for you?
Absolutely. Thank you, Katie. My email, you can do info@hrsynergyllc.com.
All right. Thank you. That is Risky Business. Enjoy the rest of your day.